dear. Oh, I'm so sorry. Where are you from then?
That's quite on brand.
Yes, Ms. Fottrell. Before we go anywhere, I want to just confirm that the arrangements that were made by my Lord Justice Baker for the media to have access to the skeleton arguments, whether that eventually produced skeleton arguments looking across the court. Did it?
Yes,
you had them?
thank you very much.
And then there was a request as to whether the media could refer in anything that they report to the content of the skeleton arguments from this moment, at the beginning of the hearing. And our view is yes, because almost as soon as we start, we'll be dealing with the skeleton arguments. And so we either say yes now or not until the end, and that doesn't make any sense. So as long as there's no difficulty with that, make it plain that the skeleton arguments which have been sent to the media in redacted form can be referred to by the media. Now, this is a public hearing. It's being conducted, obviously, in public. It's being broadcast on the live link, subject to a delay. I know that all counsel and my lords and I will do our very best not to use anybody's name or any other identifying information. Nothing is to be reported that if there's detail in the skeleton arguments or in anything said that might identify the child or the child's parents as being the subject of these proceedings, nothing is to be reported that would identify them in that way. If inadvertently anybody says anything, there's a delay on the live link, and sensibly they've given the button to my much younger colleague Lord Justice Baker. Be quick off the mark to press the pause button. But I think we'll conduct. The child in the proceedings below was referred to as S.
Yes.
And I propose to refer to him as S, and simply the parents as the mother and the father, and any other relation by their I don't know their names actually, but no. by their relationship.
Indeed, that was our intention.
Good.
My Lord, may I just begin with some preliminaries? As you know, I
certainly.
appear in this matter on behalf of S, and I appear with Professor George, King's Counsel, who sits beside me, appeared in the court below, and with Mr. Powell, who sits behind. Our instructing solicitor, Mr. Netto, who has been S's instructing solicitor since August of last year, sits at the back of the court. Ms. Fuchs, as you know, appears with Ms. Baker on behalf of the parents, and they appear with Ms. Shah, their instructing solicitor. All three appear pro bono, and Ms. Fuchs has done so, as I understand it, throughout, as has her solicitor.
And the parents are in court?
The parents are sitting in court on the right-hand side of the back.
And they're not in shot?
I understand they've been assisted by the court associates to locate themselves in the court so that they are.
That seems to be right. The furthest, the camera's over there, and it's got Miss Baker just about in shot, and then it's got the bookcase behind.
Thank you very much. My Lord, you also, of course, as you know, have written submissions in this case from the Association of Lawyers for Children, who the court has permitted to intervene, and those submissions were prepared by Miss Kavanagh, King's Counsel, but the court does not require the attendance of Miss Kavanagh. And you also have written submissions from the International Centre for Family Law and Practice, prepared by Mr. Hale.
Yes. We're extremely grateful, and I anticipate that both of those submissions, which are very full and will have required quite a deal of work and research, they're extremely helpful. We mean no disrespect by saying we'll proceed with those on paper. The focus, I think, that all three of us have is on this young boy and the decision that Mr. Justice Hayden made.
Indeed.
It may well be that some of the points in these other documents may be of assistance, but our central focus is on him.
Of course. May I just go through some housekeeping matters if it assists? The court should have a core bundle which contains all of the appeal documents, and then there are two supplementary bundles which contain documents which were before Mr. Justice Hayden you should also have an authorities bundle, and then the written submissions of the interveners are separate to all of those documents and sent to the court loose. You will know that the decision under appeal is that of Mr. Justice Hayden, and his judgment is in the core bundle at page 74. You will know also that Lady Justice King gave permission to appeal this decision, and her order doing so is at page 70 of the core bundle. And then lastly, we, on behalf of the appellant, lodged a skeleton argument, and that you'll find that at page 18 of the core bundle. I don't intend to go through that document laboriously. I will draw from it and amplify some of the points in it. If I may, I would, however, like to make some preliminary comments on behalf of S, who, of course, is not in attendance before you today.
And he, as I would understand it, just as was the case before Mr. Justice Hayden, I'm assuming he's been offered the facility of watching these proceedings, and I see Mr. Netto nodding.
Yes, he has been offered the facility of watching the proceedings. It's not entirely straightforward to do with technical issues, but also he's at school. Right. And you will also know from the position that he took in the court below that S makes this application, first of all, to the court at first instance, and secondly, to this appellate tribunal, very reluctantly.
Yes.
This is a very unusual case. It is very difficult and uncomfortable for a young person to find themselves making an application to court in which they are challenging a decision of their parents.
Unlike many appellants before this court, he's a reluctant litigant. He doesn't want to be in this position, and he held back from taking an active part before Mr. Justice Hayden, despite that judge making it plain that he, as a judge in the family division, was open to having some interaction with S, whatever that might be.
I hope my Lord will allow me just to draw out a few points in terms of S's position in relation to the appeal generally. S has met with Mr. Netto very regularly, both before the proceedings in front of Mr. Justice Hayden and since the proceedings in front of Mr. Justice Hayden. And he has about fortnightly contact with Mr. Netto. He also met with his legal team and had a conference with us on Monday of this week.
And that was the first time that you'd, as counsel, had met him, was that?
No, we met him when we were representing him before Mr. Justice Hayden at the March hearing.
Right.
We had not met him at the November hearing. The position that we took then was that we didn't want to overburden him. He was very clear as to how he wished to.
Well, for my part, I understood why you hadn't, and I thought that was a sound reason.
My Lord, the position that S is in at present, and I say this because this court should be aware of his position, but also so that his parents can hear me say it on his behalf. He continues to hope that this court will revisit the decision of Mr. Justice Hayden and order his return. That is his steadfast and firm wish. He had also hoped, either before this matter came before this court, or indeed at any stage, to negotiate some sort of resolution of the situation in which he finds himself with his parents. As recently as Monday, he has instructed us that he has had discussions with his parents about returning to the UK to complete his GCSEs. He is currently in year 8, and he will go into year 10. He's skipping year 9. He will go into year 10 in September. And it is his instructions to us that he has discussed with his parents the possibility of coming back. Mr. Netto conveyed that to Ms. Shah, the parent solicitor, yesterday afternoon, and I understand the parents' position to be, although Ms. Fuchs will obviously set it out, that they don't accept that those discussions have taken place, and I understand the parents' position to be that they intend for him to stay in Ghana until he completes his education. And that is something which is very difficult for S to accept and very difficult for S to manage. It's also important, if I may, that I remind the court of the circumstances in which S is living in Ghana. He is removed from his family, so he's not living at home with his parents or with his siblings. He is isolated from all of his social network, his friends, but also his interests and his wider social activities. You may have gleaned from the papers that this is a young man who was a keen footballer. He is also a churchgoer and somebody who was involved in mentoring other young people at his church. And I say this so that the court can understand where he is, if you like, psychologically and emotionally. He considers himself to have been abandoned by his family. On any view, he is culturally displaced, because while he had experience of holidaying in Ghana, and of course he could understand the language because it was spoken at home, it is alienating for him, and he feels that keenly. He is a British boy, he is a London boy, and he never envisaged a situation where he would be living away from his family in another country and away from all that is familiar to him. What he also feels very keenly and conveys very regularly is his separation from his siblings, both of whom he misses desperately and on whom he relies emotionally.
Is he in touch with them? I know that he speaks
He is
with
in
his
touch.
father.
He is in touch with all of his family. So he speaks
his
with
mother?
He speaks with his mother, he speaks with his father, and he speaks with his siblings. The situation before Mr. Justice Hayden, as you may recall, was that he wasn't at that time having regular contact with his mother. He is having regular contact with her now. They speak on the phone. And he speaks very regularly to his father, but also to his siblings. And of course, he has contact through WhatsApp and Snapchat and various other matters. As a matter of fact, the court should bear in mind that he is in his third placement in Ghana. He was first left by his parents in Ghana to be cared for by family friends, and he attended boarding school. He then lived with those family friends for a period of time in Accra. In August 2024, he moved to live with an aunt in another part of Ghana, and that placement broke down. And then in October, and this is recorded in the judgment of Mr. Justice Hayden, he moved to live with an uncle, who is his father's brother. His instructions to Mr. Neto...
In a third part or back in Accra?
It is outside of Accra, but
So
in a different place
place,
to the second placement. He instructs us and has regularly conveyed to Mr. Neto, and this, I think, will be information which is known to the father at least, that that placement in which he is currently living is under significant pressure. The aunt in particular, in that placement, his uncle's wife, was not apparently expecting him to live with her for such a long time, and there are significant difficulties in that placement. He is very uncomfortable there, and he expects that he may have to move on from there. He's conveyed that to his father.
And he goes to school locally?
He currently attends...
boarding school?
Indeed, he currently attends a day school.
Yeah.
When he spoke to us on Monday, he was preparing for an interview, which I believe he had yesterday, for a new school, which he would begin in September.
Yeah.
And that would be
in that locality.
That's my understanding.
Yeah.
That would be his third school in Ghana, running alongside his third placement.
Yeah.
It's important that the court has all of that information, because you might have gleaned an impression from the judgment that Mr. Justice Hayden thought that perhaps this young person was exaggerating his distress or amplifying his distress. And certainly his parents have sought to convey to the court that he is more settled than he has made out in his evidence. That is not his position. He is highly distressed at the situation in which he finds himself. He is very despondent about the breakdown of his relationship with his family. And he really is quite desperate to return to London, to return to his family, to return to his social life and the structure in which he was living, but also to return to the UK. It is a very difficult situation that some 14 months after he was taken to Ghana for another purpose and left there by his parents, there is no resolution. What is very difficult for S, and I will return to this point if I may in a moment, but what is very difficult for S is he cannot find a solution to this difficulty. He cannot resolve this difficulty. And it was on that basis that he invited us to, as it were, reach out to his parents for the possibility of some sort of rapprochement that would allow him to return.
Because as a matter of law, this is just my view, and if I'm wrong, you'll persuade me, there's nothing to stop him as an individual human being, albeit that he's a child, coming back to the UK. He's got a right of, he's a UK citizen, got a right of entry here. So if in some way he could arrange the practicalities and the finance to get himself here, he could do that. The issue for the court was whether that would be in his best interest. Mr. Justice Hayden said no, it wouldn't. His parents say no, it wouldn't. And so at the moment, the way it's set up, and this is why you're appealing, the court isn't going to tell the parents to bring him back or pay for him to come back. He'll presumably travel on his own, pay for him to come back. So you're right. It's what I had assumed to be the position. Is the difficulty for us is that he can't resolve it. It's not in his own hands to resolve this situation.
There are two points I'd make just in response to that. First of all, my Lord has hit the nail on the head. The issue is practicalities and finance, and that is something which he simply doesn't have the access or the wherewithal to deal with. But also, as a matter of fact, his parents have his passport.
Right.
So in terms of his being able to travel, his parents have taken him there, and they have removed from him the means by which he could return if he had, for example, funds, or if he had, for example, assistance from an adult or CFAB or whoever it was. And as long as his parents continue to hold his passport, then he is effectively trapped there.
Can I, if I may, just ask a slightly different
Please.
question?
Yes.
If this order stands, what is the legal position? These proceedings have come to an end. What will happen to his habitual residence if this order stands?
I'm not sure that's a question that we've given much thought to, if I may say so. He's in a slightly tricky position because he's not in the position of a young person who's necessarily at boarding school and returning to the UK. As far as we understand it, as far as he understands it, his parents intend him to remain in Ghana and not to return to the UK until he finishes school. So he's not coming and going as a child might be who's attending boarding school overseas. I might want to think about that a little bit more before I
Well, it's not an easy question to answer.
I suspect you would.
But can I follow that up
Yes.
with a related question, which is what happens when he turns 18? I appreciate from his perspective that seems like an eternity away. But what does happen at that point? Because then their parental jurisdiction, at least from the perspective of UK law, will come to an end. Presumably, he would still, one speculates, of course, his mind might change in the interim, but he might wish to return to the UK. And what happens at that point?
I'm sorry to be obtuse. In what sense? I mean, he's obviously entitled to return to the UK.
UK citizen.
Forgive me.
UK citizen?
He is a British citizen.
The court
yes.
could require the parents to give up the passport because they'd have no standing to maintain it. So if that's an impediment, that could be. It's his passport.
Yes.
He's entitled to it.
Well, my Lord, he doesn't have to stay in full-time education, of course, until he's 18. He can finish his education when he is
This is the
60.
answer to my Lord's question.
Well-
Well, once he's 18, he can come back if the immigration position is, as you say it is, that he can come back.
There shouldn't be any, as I understand it, there shouldn't be any immigration issue in relation to this young person. He is a British citizen, he was born here, and his proof of that is his birth certificate and his passport. So there shouldn't be an immigration complication. There are practical difficulties, there are financial difficulties. It is a matter for the parents as to whether or not it would remain their position, for example, that he cannot live with his parents, which I understand to be their position at the moment, although before Mr. Justice Hayden, there was a difference between the parents. The mother's position was he cannot live at home. The father's position was he would be willing to live elsewhere with him. But am I not answering your question? Your face tells me I'm not. But
Well, no. I was puzzled by your remark that education stops at 16, because that's no longer the law in this country, as I understand it. My understanding is that in this country, education now continues until 18.
Yeah, it has changed.
well, then he has to stay at school.
Well, not necessarily, because the law in Ghana, if he stays there, may be different.
What I can convey on his behalf is he wants to complete his education, and he is doing everything he can to complete his education.
He comes across as an intelligent man.
He's a bright boy. He's had a very frustrating and difficult year in which he was not attending school.
Yeah.
You will know that when he went to Ghana first, he went to boarding school. That was a very difficult experience for him, and as a result of an order of Mrs. Justice Leven in September of 2024, he stopped attending school in Ghana, and there was a period when he was having some homeschooling, which was being facilitated by his father, done online. But he is a bright, intelligent, committed student, and he wants to complete his education.
I know it's not helpful to have three people with different questions. Can I just follow up, if I may, the point I was making about what happens if these proceedings come to an end? And I asked about habitual residence, and obviously I was thinking, amongst other things, about jurisdiction, because this isn't a problem. This isn't a case which is going to stop now in terms of the dynamics of the family. Which, if this order this appeal fails, the proceedings have come to an end. Where will future issues about his future be determined, if they arise? Question one. Question two, there's nobody at the moment in Ghana with parental responsibility for him. So he's a young man technically a child in a foreign jurisdiction, unable to leave that jurisdiction under any order at the moment, but with nobody with responsibility for him there.
My lord,
He was never a ward, was he?
He was
he warded? He was warded.
was warded by Mrs. Justice Leven.
But the wardship stopped when the
Yes,
order
right.
was made.
So
The wardship came to an end with the decision of Mr. Justice Hayden.
Yeah.
there was any consideration given to it continuing.
It wasn't. It wasn't something that Mr. Justice Hayden, as I understand it, considered would be helpful. But I can see why my lord is asking the question.
The decision that Justice Hayden decided the issue that was being presented to the court then. Does he come back now? It doesn't resolve the standoff and the situation that you've very clearly described. And there were further lines of inquiry that might have been followed. They aren't elsewhere than in London, and there may have been other options from time to time that might have become live, and that there is a thought which is developing as we've been sitting here, and it's my lord's given voice to it, that there might have been some requirement for the court to maintain the wardship, even if it wasn't going to order on that day that the parent should bring him back to the UK then.
Well, there are a number of reasons why that would be helpful, but you will have seen that our position in the
Not
court...
what the appeal's about.
I understand, but just dealing with that issue, you will have seen in the court below that our position on behalf of S was in the first hearing, in the substantive hearing in November. It ran aground somewhat because Mr. Justice Hayden considered that before he would return the child, he needed to have fuller and more detailed information on options for placement. And that led to a pause. Now, what happened in that pause, and I'm happy to deal with this now, but what happened in that pause was that the local authority undertook no further inquiries with the parents, no further inquiries with the young person, and produced no further analysis, information or reports as to any other options, because the position the local authority took in the first Section 37 report was that it was in his best interest to stay where he was, and it was an appropriate exercise of parental responsibility. And that was the shutters down, if you like, on the local authority's analysis of the issues. Where that left the court, we say, is that the court didn't have full or sufficient information in terms of making a decision, which is why, in the hearing in March, a proposal that was made on behalf of S was that the court should order a further Section 37. In other words, that the local authority would undertake a further and more detailed analysis of placement options. Because one of the things that was enormously challenging for S, and to some extent for those representing S, was that the expectation from the local authority, and indeed the parents, but I understand the parents' position. The parents' position was, this is what we have proposed for him, and we will not change our minds. But the challenge for S, and for those representing him, was it wasn't up to S to propose a solution. It wasn't up to S to identify, for example, family members in this jurisdiction with whom he could live, or a foster placement as an appropriate place for his young person to go.
Can you help me on that? Because that's a bit that I'm struggling to understand. I mean, I can understand that legally speaking, there might not have been any burden on S, but why, from a practical perspective, was there not at least an evidential burden on S? Because given the standoff with the parents, he obviously couldn't live with them, and therefore he had to live somewhere else. And so therefore, why was it not incumbent upon him and those advising him to identify the alternatives?
Well, can I deal with that in two stages? First of all, the first point that my lord made, the decision that S could not live with his family, that was a decision made by his parents, not a decision made by S. So it wasn't as though S had left his family. He had been,
to be sure, but that's
their
position, and the court can't possibly question that, can it?
Well, that was the position that his parents took. Although, as I said, there was a difference between the parents. The mother's position was very firm, that he could not return to the family home and he couldn't live in the family home. The father's position was different. In evidence before Mr. Justice Hayden, the father's position was that if the court decided that this young person should return to England, that the father would be willing, if necessary, to move out of the family home and to rent a property, and S could live with him there. That was one option. In terms of the obligation on S and or those representing him to, as it were, provide solutions, S did file a statement of evidence in which he suggested a number of family members or friends of family who may be able to care for him. And of course, those representing S, Professor George, Mr. Powell and myself and Mr. Netto, put forward legal arguments in relation to Section 37, providing a vehicle for further analysis of alternative options in state care, that being foster care, and indeed assessment of those family members that he put forward. But the point I was making, and perhaps rather clumsily, is if the factual situation is that parents decide, without consulting the young person, but I'll come on to that at a different stage, if I may, parents decide that the young person can no longer live at home, and the solution from the parents' perspective is to take that child to another jurisdiction and leave that child in the care of friends and family. It is, in my submission, quite a burden to say that if the child is to be allowed to return, the child has to set out what the alternative arrangements for their accommodation in this jurisdiction should be. Legally, of course, we can do that, but he can only make suggestions as to there is this aunt in wherever she was.
I fully understand that. It's an exquisitely difficult position for a young person to be in. But if, as is the case, that young person is Gillick competent, and if they have that degree of autonomy, and they're putting forward a proposal which is different to the one that their parents favour, isn't it incumbent upon them to not only say, I want to come back to the UK, but to have some proposal for how that can be safely achieved?
Perhaps I've expressed myself clumsily. The position that we put before the court was, these are the people who I think I can live with. That's what S said. They're friends, there's a relative. and if these are not the people I can live with, then I am willing to go into foster placement. That was the position that he took on his return. He also, of course, would have been willing to live with his father if his father had moved out of the family home. The framework to achieve that, we submitted on his behalf, was a further Section 37 report, because his proposals had not been properly evaluated and analysed by the local authority.
There's no ground of appeal about the failure to order a Section 37. Further section, sorry. It's mentioned in your skeleton at paragraph 25 under a ground that doesn't deal with that with respect. I'm not saying you can't run the point now because we want to get to the bottom of this, but it's
well, I suppose
it wasn't in the front of the shop window.
No, I suppose I'm raising the point in response to the question which I was asked by Lord Justice Baker. And the question I was asked is, if we are in a situation where the wardship has now ended, and if the decision of this court is to uphold the decision of Mr. Justice Hayden, the court below, what happens to the habitual residents?
It's without at all being critical, but it's an unsatisfactory position for this court to be in June 2025, to be tantalised, for example, by the prospect of this paternal aunt being an option. The fact that that aunt was there and might be an option seems to have been known, at least in the run-up to the final hearing before Justice Hayden, but it's not apparent on the evidence I've read that either party, the parents or those acting for S, put in evidence saying we have been in contact with her and she says this or that. But here we are now, 3 months or more after the hearing before Mr. Justice Hayden, and there's still complete absence of knowledge. So we don't know whether, if there was a Section 37 report, whether she'd even answered the telephone, as it were, or whether she would open her arms and say, why doesn't he come here? And that seems to be an unsatisfactory position.
Well, my Lord, may I deal with it in the following way? I accept that it is an unsatisfactory position, first of all, but may I deal with it in the following way? S put in a statement before the hearing in March, setting out his proposals for his care. Our skeleton argument before Mr. Justice Hayden, and it's dealt with in his judgment, was that the vehicle to look at placements was a Section 37. And that was the argument that we put before him. What we did not do on his behalf was to contact any relatives, because there was a concern that that would lead to discussions within the family, and there would be pressure on relatives not to put themselves forward. So it was a very awkward and difficult position. What S was asked to do by those representing him, as you would expect, is if you were to come back, who would you stay with if it isn't your parents? And what he gave was a list of family members, and he explained in his statement why he thought there were people with whom he could live. What we couldn't do on his behalf was action that any further. It was a criticism that we made in the court below of the approach taken by the local authority. Now, we do not make an attack on the Section 37 decision by Mr. Justice Hayden, but what we do say in ground one is that Mr. Justice Hayden did not look at all of the options that were open to this child in terms of return. One of the reasons he didn't look at the options was because he didn't order a further Section 37.
Well, exactly. I mean, you make that point very clearly in your skeleton argument, but surely that is attacking his decision, because what you're saying is he said it was premature to order return before a second report, and never went on to consider whether to order a second report. So surely the reality of that is you are attacking.
Yes. Well, maybe I'm coming at it through the framework of ground one, which is the failure to look properly at all of the options. And
that's really your argument. Your argument is that he was looking at it through the prism of parental responsibility rather than the prism of welfare. And
yes.
That's real cases.
Yes.
Really. And section. But would it have been appropriate to ask for another Section 37 if he wasn't contemplating making a care or supervision order? This court's looked at Section 37 fairly recently, as you will know. It's a narrow power to make a 37.
It is.
Direction. It's only if there. And having decided that it wasn't an option, would is appropriate? And there would have been, under wardship, there would have been other ways in which he could have got further inquiries underway.
Well, there are a number of different ways that he could have gone there, but as it were. But one of the reasons why we proposed a Section 37 mechanism was because there had been a Section 37 report. There was a social worker engaged. There was a local authority involved with the family, and one of the evidence for the court in terms of the viability of options would most easily come through that route, because somebody would have to investigate, as my Lord the President indicated, are these relatives who are willing to care for this child? Are these placements that are viable? Is this something that should be done, for example, under a public law order, or is it something that should be done under private fostering or wardship? But the difficulty is, if it is not done by means of a Section 37, then the court is using its powers under Section 100 to require a local authority to do something which it should be doing under a statutory provision. And I recognise that a second, as we did in the court below, I recognise that a second Section 37 is an unusual thing to require the court, to require the local authority to undertake. But there are two reasons why, in this case, it was the appropriate vehicle. One is, as I said, there were unassessed options, unexplored proposals. And the way in which Mr. Justice Hayden dealt with the options, I'll come to in a moment when I get to ground one, which I'm sort of in now, but not quite. But the other reason why it was appropriate to use that mechanism is because it was inevitable that on this child's return, some sort of local authority support was going to be necessary. It needn't have been under a public law order. But if, for example, the placements with friends and families were not viable, then one was looking at public law placements, a foster placement for this young person.
I think we shouldn't be too hung up upon the legality of Section 37, because if the judge thought he wanted more welfare information, then he could have ordered the local authority to provide an ordinary welfare report under Section 7. And they were the obvious target for that request, because they'd got their head round the case, and the social worker had spoken to the boy. So I think, although my Lord and I are interested in whether or not the judge legally had, if he was exercising matters in strict legal sense, jurisdiction to order Section 37, I don't now, having worked it through just now, think that's a problem. If he wanted more welfare information, he could have got that under Section 7.
We might put it slightly, I understand my Lord's point, we might put it slightly differently. The question might be whether he needed more information.
Yes.
That's a slightly...
If he did need it, he could have got it by some route or another.
There are a number of means, but I understand.
My Lord Justice Arnold's point, it's paragraph 38 of the judgment, which says, however, given the objective of Section 37 report will be to identify cogent and realistic welfare options, any return prior to the report would be premature. And so one might say, certainly from your side of the court, that any adjudication prior to any further report would be premature.
I think we would say that, but we would also say, and this is part of ground one, that the court had to explore all of the options that were before it, and there's a somewhat linear analysis.
Well, it goes back to my Lord's point. Simply making a decision on this point, on that day, doesn't make the problem go away.
Indeed.
As you've described. Can I just, lest it's lost, at the beginning of these are very helpful submissions by you, you indicated there'd been a phone call on Monday and you'd heard about discussions that had been, your young client was saying he'd had with his parents and some dispute about that. Nobody, and by nobody I mean the parents and S, should feel that now the Court of Appeal process has started, there's some embargo on them speaking to each other. It may or may not be the case that we will be able to give a decision today, but we certainly won't give our judgments today. It sounds odd to say it, but the window for discussion remains open, and often a hearing like this raises everyone's awareness of the issues, by everyone I mean the parents and S, to an acute level. And I wonder whether any thought's been given to bringing in a mediator who might be skilled in working with young people and parents, and may be able to work internationally, which is sometimes the case. So I just put that out there. It's never too late. This is a family problem. These parents have done what they did out of love for their child. It's tough love, but they've done it. He's where he is, and I'm sure they hear your description of his life over there. They'll have their own view of it. They know more about it than any of us. But it's not a very satisfactory position, and it may be that the family can in some way resolve it. And I certainly wouldn't wish them to feel that because the court's involved, there's any inhibition on them getting on, talking to each other, either with the mediator or in any other way.
Well, my lord, I'm grateful for those remarks, and I know that they will be very welcomed by S. He was keen, as I said, for any discussions and negotiation. And he continues, as I said, to meet with Mr. Netto very regularly. Those of us who represent S stand willing and able to assist in terms of any negotiations and any discussions.
Now, because of the way the hearing has taken, we've down a number of helpful paths and probably got to matters that are concerning us.
Can I just ask one?
Yes, but
one final question.
Then we must get to your grounds of appeal, and you make your submissions as you had planned to do when you woke up this morning.
I think my final question will help you in that respect, and it's this. What order are you asking us to make today?
Well, in our application, you will have noted that the order we were asking the court to make was to make a return order for this young person. If the court is not minded to do that, but minded to grant the appeal, then we would ask that the case is remitted. But I say that reluctantly, because this is a young person who is not looking to find himself in extended litigation with his parents, and I dare say the parents would not wish to have to engage further in litigation. But if the court, for example, considers that the appeal should be allowed, there is a need for a pause and a consideration, whether it is within the framework of proceedings or out with proceedings. There is a need for a pause and a consideration. What happens to him? Where does he go? Who does he live with? And where does he live? Those are matters.
But that's precisely why some of these questions remain pertinent, because suppose the case is remitted. That leads to the next question. Remitted on what basis and for what purpose?
Well, my lord, it would be remitted to consider his application to return under the inherent jurisdiction.
But I'm sorry, but that doesn't seem to me to be a complete answer. Number one, does wardship get reinstated? Number two, what about a Section 37? Is the idea that issue be ventilated again in the court below? What happens?
Dealing with the first issue, we would say yes, he should be warded. He should be restored to the legal status or under the same legal framework that he had before Mr. Justice Hayden on the orders that were made by Mrs. Justice Leaven in September of last year. In terms of whether there should be a Section 37 or anything else, we would say that that is a decision that should perhaps be made by the judge to whom it is remitted. What there would certainly need to be is evidence. What there would certainly need to be is further assessment and further consideration about placement. If this court were to order his return to this jurisdiction immediately, we would need to consider with him where he intends to go.
Yeah, but that leads on to the point that we've been bumping up against, so let's make it explicit. Is it realistic for this court to order his return immediately?
Well, my lord, that's why I've proposed that the matter should also could also be addressed by way of remittance.
By way of?
Remittance to the lower court.
Your instructions are he wants to come back now.
He desperately wants to come back. He desperately wants to come back, and the application for appeal was to get an order from this court that he would return. But we see the difficulties with that, and we see that if this court is persuaded that Mr. Justice Hayden was wrong, then it's going to have to be looked at again. Because if Mr. Justice Hayden fell into error,
but that presupposes that upon remittal, the court is going to be in a position to take a better decision. And I'm not attracted by some kind of open-ended remittal, which doesn't ensure a better decision.
I suppose there are 2 points I'd make in relation to that. We would hope that if the case is remitted, it could be listed relatively urgently for a hearing before a judge. And the question to be considered before that judge is what evidence will be needed in terms of placements for this young person to return. Because the difficulty that we have on behalf of S, and I won't go around the houses on this again, but he has made the proposals he made. There is a local authority report which doesn't address those proposals. A court at first instance, if it is to make this decision, will need those matters to be further investigated. And obviously on behalf of S, we can do what we can do to provide the evidence and the legal framework within which that happens. May I just, before turning to the grounds, which I will do in a moment, may I just make a few brief factual points which emerge from the facts in the court below, just to remind this court. You will know that S is one of 3 siblings of his parents, and you may have gleaned from the papers that the family had some involvement with children's services in 2014 and 2016. But these events, which led to his removal from the jurisdiction, began in effect in July of 2023, when he came to the attention of his general practitioner, who made a referral as a consequence of his mother using excessive physical chastisement of him. And you will know from the core bundle that the GP's referral, which is at page 323 of the core bundle, led to what is called a safe assessment, which was undertaken by the relevant local authority, and the safe assessment was completed in November of 2023, and you'll find that document at page 296.
Just to, you pick upon July 2023 and say that it all started with a referral to Children's Services from the GP because it is said that the mother used excess physical force. But Mr. Justice Hayden listed no fewer than 21 factual events that led to this. And the first 2 of those predate that. But one is that in the school year 22-23, he had 25 unauthorised late attendances. And the following year that had risen to 50, which is about a fifth of all the possible attendances. And then in June 2023, he was issued with an internal exclusion order for 2 days from school. So I think it's not helpful to just pick upon one. The judge found there was a pattern, and it started in the school year 22-23.
I understand. Perhaps I can put it a different way. The account, which is very full and thorough, as one would expect from Miss Fuchs, of the history, which is set out in the judgment, is taken from the parents' document, which is before the court. What I ought to have explained is there are certain issues from the perspective of S which are not reflected in that document, and I'm simply, as it were, filling in those points. So I hope that assists. From the point of view of the young person with whom you are concerned, these were the seminal events, the parents' referral to the safe assessment, and then the safe assessment which was carried out. I mentioned earlier, and these are points that S would wish us just to remind the court, the safe assessment was undertaken by Miss Sope, who was not the person who completed the Section 37, and it brought out a more nuanced and balanced picture of this young person. His attendance was recorded in the safe assessment at school, and this is at page 299, as being good. 299 of the core bundle.
The core bundle.
Yes.
So just whilst we're paused, there's a gentleman kindly brought a box into the court. Are you wanting to deliver that to someone?
Yeah, I'm sure it's too late and they've probably been handed up. I don't know who's clerking the court today.
No? Right. Is anyone in the case expecting a box of further folders?
No.
No? Are you in the right court?
Is this mine or no?
Yes.
I can hand them up regardless.
But Miss Baker, would you mind having a word with the gentleman, just perhaps outside, just to clarify what's happening? Because he's doing his best, but it is distracting. Yes, now I've forgotten the page number.
299.
299. Right.
And what it records there is that the head of year told the social worker, your attendance is good, however you're often late and homework is an issue. In general, you are making good academic progress. And that is something which is obviously important to this young person. If you continue down the page to 300, top of page 300, you'll see that he is a regular churchgoer and that he is somebody who, in his church, was mentoring other young people. And that, again, is something which was important to him. At page 301, he was described by the social worker as polite and friendly. Forgive me, the top of page 300, he's described by the social worker as polite and friendly, appropriately dressed and open during the conversation. And I make these points because when reading the judgment, and of course one understands the basis upon which the parents is put, but there is a lack of balance to some extent of the commitment of this young person to his own education, and you will understand that he paints a much more nuanced picture of his circumstances before his removal in March of 2025. In terms of the proceedings and the instituting of these proceedings, you will know that he met with Mr. Netto in March of 2024, and he has shown some considerable resilience and commitment in terms of launching these proceedings, knowing that they would cause upset and annoyance to his parents. There are two pieces of evidence that I do want to remind the court of, and I think these come through in his judgment, in the judgment of Mr. Justice Hayden. First of all, in his written evidence to Mr. Justice Hayden, and this is at page 214, paragraph 2, he told Mr. Justice Hayden, I feel like I'm living in hell. That wasn't just to do with the physical circumstances in which he was living. It was to do with his isolation. And then again, at a later stage, in paragraph, or on page 216, he told Mr. Justice Hayden he absolutely hated living where he was. But thirdly, at paragraph 215, forgive me, page 215, paragraph 3, he provided the court with quite an important piece of information. If I had known about moving to Ghana in advance, there was no way that I would have agreed to it.
Yeah. Well, the judge found that, didn't he?
The judge accepted that evidence. Yeah. And indeed, that was common ground between him and his parents.
Yes, well, they did what they did because presumably they assumed if he'd known he wouldn't. So.
Indeed, it was their case that had he been told, he wouldn't have gone. Now, one of the issues, of course, that we raised, it matters not because it wasn't a position that he was in, but had he been, as it were, tipped off about the plan to remove him to Ghana, and had he then made an application to the family court, we would query whether the family court would have allowed his parents to exercise their parental responsibility in the way that they did. And so he has deliberately been placed at a significant disadvantage and in a position of procedural unfairness.
And the judge was, whilst he was understanding of why these parents did what they did, he was critical of them.
He was critical up to a point. He was critical in the sense
I deprecate the parents' deception. I've no doubt he would not have gone willingly.
What he did not consider was the impact of the parents' deception on the young person's welfare and on their best interests. What he did not consider was the impact of that on their emotional well-being, their psychological well-being, and that, of course, is the criticism that we make in relation to the judgment. Shall I move on then and look at the grounds? You will know, of course, that the essential legal issue in this case, and we've treaded across various different grounds, but essentially the legal issue in this case is the tension between adolescent autonomy and the exercise of parental responsibility. But it's important, we say, to recognise that it's not adolescent autonomy per se as a standalone concept. It's adolescent autonomy to either make decisions or to participate in decisions, and to be heard and listened to in relation to their own welfare best interests and how decisions impact on their own welfare best interests. We make that submission because, of course, it's not controversial that parental responsibility exists by law for the benefit of the child. And the entitlement of parents to make decisions about their children exists to allow them to make decisions for the welfare best interests of their children. Now we say, and I understand this is not entirely accepted by the other side, but we say that the entitlement of a parent to exercise parental responsibility is diluted gradually through the adolescence of young people, and it is diluted by the acquisition of autonomy. And that is something we say that Mr. Justice Hayden did not look at in any depth in this judgment. We do remind the court of a number of key points before I look at the grounds. There is no dispute in this case that S is Gillick competent, and also that the scope of parental responsibility has to be assessed or viewed against that backdrop. What there seems to be some dispute about is the impact of Gillick competence on parental responsibility, but I'll come back to that. A second point that we say is central to your evaluation of the grounds and your consideration of the grounds is, of course, that S was permitted by Mrs. Justice Leven to be directly instructing his legal team and to be separately represented in these proceedings. And then a third point, and again we make this at the outset, and it infects, if you like, or informs all of the grounds, is that we say it is contrary to a young person's welfare best interests to remove him without consultation at all, against his will, from his place of habitual residence, and to do so by an act of deception, understanding that were he informed, he would refuse to go. Now, may I turn to ground one?
I don't want to turn this into an academic discussion. If the young person was about to enter a building which was on fire and about to collapse, and the parents, and he was determined to get in because his favourite whatever was in the building and he wanted to rescue it, but the parents removed him because against his will and without consulting him. This is not this situation at all. There must be circumstances where, although the young person isn't consulted, and although they really, really don't want to have the outcome which the parents wish to achieve, that it is per se always going to be contrary to their welfare best interests. Sometimes parents have to act
of course, we
to
accept
protect
that.
their child.
I hope I put it carefully when I made the submission. The real mischief here is removing a young person from their country of habitual residence and taking them to another jurisdiction.
It's a major, major invasion of that person's autonomy.
It is a complete alteration of his minority and where he lives it and how he lives it. And it isn't just somebody being sent to boarding school in Scotland and that not being what they want or wherever it is. This is a decision being made that this young person.
I just reacted to the assumption behind your submission was that to do what they did is bound to be contrary to his welfare best interests.
Well, I hope I began that, and if I didn't, I intended to, by saying that the mischief here, and I believe the submission I made was that it was contrary to his welfare best interest to remove him without consultation from his place of habitual residence. And by that, I mean his country.
Yes, that is what you said, but even so, it's not. Yes, okay.
It's not forgive me.
To Ghana, to a place a long way away, where there is nobody. He's isolated completely from anybody he.
And culturally, although it's his his heritage, the way life is lived is wholly different to the way he'd been living his life.
Indeed, but perhaps if one stands back for a moment and considers this scenario, if, for example, this was a private law dispute between parents and a child was being relocated, a court wouldn't tolerate a relocation of a 14-year-old young person, or a 13-year-old young person as he was at the time, without any consultation, first of all. And secondly, if there was consultation and there was resistance, then that has to be factored in terms of the welfare analysis. So it's the subterfuge and the deception which impacts very significantly on the young person's welfare best interests. And that, of course, impacts on the process of consultation, but also the substantive concept of consultation. I accept that this court and other courts will take the view, and have taken the view, that parental responsibility is a powerful and important concept, and that parents do have decision-making capacity about where children live and where they go to school. I understand that. But our point is twofold. First of all, that it wanes as the child gets older and dilutes, and secondly, that it must be exercised in accordance with the child's welfare best interests. And if for example, you deny, you ignore, you do not take into account a young person's wishes and feelings, or their intention to travel or not travel, then you are acting contrary to their welfare best interests. It is a unique set of circumstances, the taking of the young person without telling them. What I proposed doing, which I hope will be of assistance, I know I've been speaking for almost an hour and I haven't yet hit the grounds, but I will hit the grounds. What I propose doing, if it assists, is to take some of the grounds together. So I'm assisted by Ms. Baker and Ms. Fuchs' approach to take grounds 1 and 4 together, and I would propose taking grounds 2 and 3 together, because there's a crossover between those grounds, and I may not have much to say about grounds 5 and 6. So dealing first of all then with ground 1 and ground 4, the particular complaint that we make there is that Mr. Justice Hayden reached a conclusion in his judgment that the decision of the parents was one which fell within the generous ambit of parental responsibility. And we say that he fell into error in that respect, in that regard, in 2 respects. One is that he didn't properly or fully engage with the various options that were available to this child in terms of placement for this family. And the second was that he didn't properly engage with the question of the young person's best interests. Now, it may be of assistance to actually look at the judgment of Mr. Justice Hayden. And if I can take you or signpost for you a few paragraphs of that judgment in terms of where we say he fell into error. You will find the judgment at page 70.
74.
The writing is so small I can't read it. 75. So it begins, the proper analysis begins, the proper summary begins at page 76. And Mr. Justice Hayden really starts to look at the issues in terms of the options at paragraph 12, when he sets out the legal framework. At paragraph 13, he deals with, and this I think is the point that my Lord, the President, highlighted a moment ago, he deals with the position in relation to S's life in London and the fact that he was duped into a move to Ghana. And then he records that nobody has disputed that he is Gillick competent, and that accordingly resolution of this application requires his own views to be factored into the best interest decision in relation to his welfare. No difficulty with that.
That's the first reference to best interest decision.
Indeed.
Related to his welfare in the judgment.
Yes. And then he goes on to make the point, and there's no dispute with this, that his views are to be afforded significant, though not determinative weight. And then he properly quotes, we would say, from the Gillick authority, but also my Lord the President's decision in Re E, and the decision of Sir James Munby in the Re X case. And then at paragraph 14, he deals with the UN Convention on the Rights of the Child, on which you've been addressed at some length by the Association of Lawyers for Children. And then he goes on at paragraph S to deal with the representation of S. He returns to the issue of the parameters of the decision in paragraph 17, which begins, though these are wardship proceedings, the central role of parents, and he goes on to deal with section 3 of the Children Act, setting out the position in relation to parental responsibility. And then he sets out a number of authorities dealing with the parameters of parental responsibility, and in particular the quote of Lord Templeman, first of all in KD, you'll see, and beyond that the observations of Mr. Justice Headley in the Riel case. But then at paragraph 18, he quotes my Lord Justice Baker's decision in the Aisha King case at first instance.
Yes. That passage was considered by my Lord in a subsequent case.
Indeed.
And importantly explained by the
Indeed,
President.
it was.
And so that passage should not be regarded as having any particular great weight, Ms. Faltrell.
No, well, my Lord, we make that point in our submissions, because by quoting that passage in that way, Mr. Justice Hayden fell into error. And perhaps if we pause there for a moment, my Lord Justice Baker referred to the subsequent decision of the President, and that was in the Yates case.
That's right.
And in the Yates case, if it helps to look at that.
It would help me.
Yes.
Yes.
Actually, it would help me because I'd forgotten if I did do that, what I said.
I remember being...
yes, but I'm sure you remember it. Stinging me.
The Yates case is in the authorities bundle. It's tab number 7.
B.
Forgive me, it is B4, and it is at page 156.
Yeah. Tab 4B. Yes.
Now, it may be helpful to look first at the head note, because, of course, what was occurring in the Yates case was that the parents were seeking to rely on my Lord Justice Baker's comments in the Aisha King case.
But Aisha King was not the same sort of case, but hadn't she been removed?
It was a similar case, but it was a case involving a young person who had been removed from the jurisdiction in order to obtain treatment. Proceedings.
That's right.
Indeed.
That's right.
And had been taken, ultimately, I think, to the Czech Republic.
But by the time it returned for a decision before my Lord Justice Baker, issues had been resolved.
Yeah, it was. It wasn't a judge. It was a short judgment reflecting an agreed order. It wasn't anything more than that.
No, but the
anyway, where's the passage where my Lord?
And then Yates is the Charlie Gard.
Yeah,
Yates is the Charlie Gard case. If you'll just bear with me, my Lord addresses this issue.
My Lord explains it in paragraph 61, the background. And then...
If we just bear with me one moment.
Paragraph 104.
Just bear with me. I've just lost my place in the bundle, so I have it highlighted in the document.
I can't help.
So it begins to look at the decision of Lord Justice Baker at paragraph 62. And at paragraph 62, my Lord the President set out the decision of Mr. Justice Baker as he then was. And then at paragraph 63, there is consideration of the parents' case in Charlie Gard, who were seeking to argue that Mr. Justice Baker had introduced a threshold step, as it were, into the inherent jurisdiction of the exercise of parental responsibility. In other words, that a court would have to be satisfied, a way of reading, or the way of reading my Lord's comments.
It's paragraph 66 that Mr. Gordon, who was leading counsel for the parents in Charlie Gard, submits that a similar rationale underpins the application of the significant harm criteria in the context of medical treatment decisions. And he was building that submission on the back of the Lord Justice Baker's earlier judgment. And then does our judgment...
Cutting to the chase, it's 104, 105.
Does it take me that long?
There's the passages I've cut out and kept.
Thank you.
So my primary conclusion, therefore, on looking at King, yes. Baker, J's words, provide no basis for saying he was holding that any test. Yeah.
But if he did say that,
it may be of assistance to begin perhaps a little earlier at paragraph 95, because my Lord the President did a wider review, as it were, of other authorities. So from paragraph 95 to paragraph 97, and then dealing with the interpretation, or the correct interpretation of my Lord's comments in the Charlie Gard case, that is at 104.
Thank you. So, in terms of a micro point within the submission, you say that if Mr. Justice Hayden was going to go down this road of looking at the ambit of parental responsibility, and he was going to choose 3 authorities to support his approach, he was in error in relying upon what my Lord had said in Aisha King.
Well, my Lord, it's perhaps
putting
more
it
than...
putting it too high.
It's putting it too high, but it's also perhaps more than a micro point, because the submission that was made to him by my learned friend Miss Fuchs was that if the parents are lawfully exercising parental responsibility, that the court should be very reluctant to intervene or to interfere with that parental responsibility. Just forgive me while I come out of the authorities' bundle. So just returning to the judgment, it's not just the fact that he erroneously referred to the Aisha King judgment and the paragraph, it's that his own interpretation of parental responsibility was too broad. And we say, of course, that where he landed was that he was satisfied that this was a responsible or appropriate exercise of parental responsibility, or it was within the bounds of parental responsibility. And the consequence, of course, of his quoting from Aisha King is an indication of his applying, if you like, the wrong test. And although he comes back at a number of places in the judgment to indicate that he is aware that this is a best interest decision, our submission is that he doesn't actually properly confront or grapple with that. So
well, he does after, forgive me, but he does go on after this exposition.
He does indeed. He does indeed.
Which no doubt reflected the submissions that were made to him,
yes,
on the other side, to have the kernel of his judgment is headed the best interest decision.
Indeed, but I was answering my Lord's point, which was that the Aisha King case was the wrong case to refer to.
Yes, I said micro point. You're right to pick me up. What I meant was it was a discrete point.
Indeed, but it does inform his thinking. So if one turns then to the judgment where it is headed the best interest decision, and this is my Lord's point, in our submission it is clear that Mr. Justice Hayden had in mind the obligation to wrestle with the concept of best interests and to identify and analyse and examine the best interests of this young person. But we say that he didn't properly grapple with that. So if one looks then at paragraph 22, he sets out at the top, in turning to the welfare analysis, he remarks on the fact that I'm entirely satisfied the parents wish for him to be educated, motivated by their deep love and so on. And then he goes on to look at the evidence in relation to the young person. And at the bottom of paragraph 23, again, he refers to it is argued, as I understand, that if these parental concerns are not justified on the basis of available evidence, they should be afforded significant weight, even though the fears may be genuinely held. And then further down, he sets out all of the evidence which he had heard and on which he relies. So you have the NSPCC guidance, which he sets out.
Yeah.
And then you have the long extract from Miss Fuchs' position statement, which begins at paragraph 27, Roman numeral 1, in which he sets out all of the factual matters, which were, he said, properly drawn from the evidence.
Yes, and he also, the NSPCC guidance, which he obviously found helpful, has at 25 a list of the sorts of behaviour that those concerned that a young person might be moving into criminal activity or criminal exploitation might see. And he makes the point that these were, to a degree, evident in the various findings that he goes on to make.
Indeed. And then, my lord, at paragraph 29, he moves on from his consideration of that factual evidence to the section 37 report. And you can see a number of excerpts there from the section 37 report, and that carries on through to paragraph 30. And then he sets out some other issues in terms of the social workers' analysis. And in particular, paragraph 32, you will see that there was a criticism of the section 37 report.
Sorry, did we... sorry.
This is
I was
all
distracted. Did you note at paragraph 28, having listed the 21 different factual elements that he had noted, that he says, I am satisfied that S was involved in criminal activity and in or on the periphery of gang culture. And he gives some further reasons. So that's a finding.
Indeed.
Yes.
Yes.
And it's on the basis of that finding that he goes on to conduct the overall welfare balance, which you're critical of.
It all comes under, as we understand it, the umbrella as best interest. That's the heading, and the consideration of the evidence, the finding that he makes, drawing on the NSPCC guidance and the evidence of the parents.
And your ground 5 attacks the findings, a fact which we'll no doubt come to.
Well, my lord, we are critical of the findings of fact that he has made.
You aren't.
We are.
You are, yes.
Yes. May I come to those?
Yes, but I'm
because
just...
the primary issue here is the best interest in us. And forgive me, I'm taking
at certain stages of your skeleton, you use, now of course I can't find them, you use phrases that the judge assumed or the parents alleged. Well, these were findings of fact.
Yes, I understand.
Whether they're supported or not is another matter, but they're more than assumptions by the judge.
Yes, I understand that is the legal position.
Yeah.
You will understand that the position that S takes and the position that we advocate on his behalf is that the court is not entitled to reach those conclusions, or it was wrong in reaching those conclusions.
Yes.
But I can put it no higher than that. He didn't give evidence. He wasn't in a position to, or chose not to, interrogate.
He'd put in his statement, he does address some of these episodes, and he says, look, they've got the wrong end of the stick. It wasn't, okay, I did have a coat, but it didn't come by any nefarious means, and people have misunderstood, etc., etc.
He is very clear, or was very clear at the hearing in front of Mr. Justice Hayden. He was very clear in the discussions with social workers at all stages. He is very clear today that he is not engaged in any criminal activity. And he was also very clear that he didn't accept the parents' assumptions that they had made.
Yeah.
And that's why we use the words that we use, but I understand the legal point that my lord makes is that is a finding. I understand. The exploration that I'm inviting the court to engage in relation to the judgment relates to the extent to which Mr. Justice Hayden explores the question of best interests, it all coming under the umbrella. So if we can return to the judgment, at paragraph 32, he acknowledges some criticisms that are made by those representing S. And he is clear that the social worker arrived at his views independently. However, he goes on to say, the last second last sentence of paragraph 32, I do consider that the report focuses heavily on the appropriateness of the exercise of parental responsibility in the decision to remove S to Ghana. As I have explained in my outline of the legal framework, the decision here is wider than that and requires a broader analysis of best interests.
Isn't that the problem with your ground one then? Because there he's acknowledging that the author of the report may have erred in the way which you're saying he did, and he corrects himself or corrects the author of the report and puts himself back, as it might be, one might say, in the right lane.
Well, he was aware of the necessity to consider best interests. The criticism we make is that he didn't consider it properly. He repeatedly, twice in the part of the judgment that I've taken the court to, he refers to the fact that the test is broader than just the entitlement of the parents to exercise parental responsibility. That's a criticism that we made of the social worker. And at the bottom of paragraph 32, Mr. Justice Hayden acknowledges that he is required to take a broader analysis of the issues. And he goes on then to do that, as we understand it, from paragraph 33 to paragraph 42, that being the conclusion of the judgment. So first of all, he looks at the issue of concealment, and this is the point that I made to my Lord the President earlier. It's right that Mr. Justice Hayden acknowledges that the concealment was a breach of trust, and it's right that he acknowledges that it was a breach of his entitlement to look for what he calls truth, honesty, and respect from his parents. And then he says their actions jeopardised their son's happiness and emotional well-being. But we would submit that that is not sufficiently broad in terms of analysis of that, the impact of that particular event. Because, of course, a decision to remove a young person without telling them from their home country is, we say, emotionally harmful to that young person. And there's very clear evidence that it was emotionally harmful to this young person.
Yeah.
The evidence that he gave to Mr. Justice Hayden, that he was in hell, as he described it. And so if one reads that paragraph 33 in its entirety, it's right that the judge does acknowledge that that was a harsh decision, but he doesn't refer in that paragraph, or indeed elsewhere, to the impact of that decision.
Their actions jeopardised their son's happiness and emotional well-being. Doesn't that reflect 33?
My Lord, I think I took the court to that at paragraph 33.
Yes, doesn't he recognise that the effect of...
He does recognise it. My Lord, he doesn't go on to consider it in the context of welfare best interests, and doesn't come back in that exercise, in that to that point in the balancing exercise. There's a minimising, if you like, of the relevance of that particular event, because of course the young person's evidence to that court and to this court is that that event in itself was extremely damaging to him and enormously distressing. Finding himself, and it's helpful to look at what actually happened. He was taken to Ghana and told that his grandmother was unwell. When he was in Ghana, he was told that everybody was going back, but he was staying behind. That is what happened.
I wonder whether the concealment is... I mean, it's a striking feature of the case. But how important was it for his ultimate welfare decision? I'll let you take Mr. George's correction.
Shall I take my Lord's question and then I'll come back to
Mr. George. My point was the concealment's a striking, the way in which it was achieved is a striking feature of the case. But he had to consider make a welfare decision on the ground now, what should happen from now. And it is perhaps a better point on your side that he didn't consider the emotional harm that the young man is suffering now and will continue to suffer.
I suppose it's two issues, isn't it? Because the difficulty with the concealment is somebody is taken somewhere they don't want to be without any preparation. And that isn't something that just passes.
No.
That is quite a shocking experience psychologically, and certainly the description of the young person in his evidence was that it was quite shocking. What he also seemed to have the impression, and this is borne out by evidence in communications between the parents and the school, is he was initially given the impression he would be there for a short period of time, or a term, or perhaps slightly less or slightly more. What occurred over time was the initial deception and then the continuing effect of the deception. And I suppose the point that I'm making, perhaps not terribly clearly, is that if you look at paragraph 33, that's a rather reductive observation as to the impact of the deception, that it was an immediate impact and not a continuing or lasting or consequential impact. I suppose the other point is it's not a single event. You don't just take him, he's not coming back. You are moving the centre of his life to another place.
You make criticism that the judge doesn't conduct the welfare exercise thoroughly, and whilst this court is not going to say to a judge of this experience that he should have set out the welfare checklist and gone down it, had he looked at item E on the welfare checklist in section 1 of the Children Act, subsection 3, any harm which he has suffered or is at risk of suffering, I suspect you would submit that that would involve him making a finding as to whether what happened in going to Ghana and then being left there caused harm, and whether being required to stay in Ghana would cause him harm. The judge, I'm looking at paragraph 42, and in that way I'm taking you out of your course, but that's where he deals with harm, and he doesn't really make the findings at the level at all that you're describing. It says that there can be no doubt S's move to Ghana was a big cultural shock to him, one that was unexpected and for which he was unprepared. Life for him there is very different. He balks at some of its inconveniences, especially the power outages. However, it's also important to remember Ghana is an important facet of his cultural identity, etc., etc. And then, last sentence, as is clear from my analysis of the evidence above, I consider S is at real risk of suffering greater harm in returning to the UK than if he were to remain in Ghana. But he hasn't really found what the harm is in Ghana, not only to date, but if the decision is no, you're not coming back, what that harm would be going forward. And I think, for my part, if that's your criticism, which I've put into your mouth.
Well, in fact, that is precisely the point that Professor George made in the note that he sent to me a moment ago. The difficulty with the analysis at paragraph 33 and indeed at paragraph 42, and insofar as it threads through from 33 to 42, is there is an acknowledgement of a risk which arises from the events, but no acknowledgement of actual harm having been caused and continuing harm, which I think is my Lord's point.
Yeah.
And that is a deficit. And I accept the point, as I must. I accept the point that is made very attractively by Ms. Fuchs in her document and has been made repeatedly by this court, that the judge is not required to mechanically go through the welfare checklist or indeed to recite all of the evidence and all of the matters which he took into consideration, and certainly not a judge of this seniority and experience. But it has to be right that the judge has to consider the possibility, that's the wrong way of putting it, that the judge has to consider whether or not this child has actually suffered harm as a consequence of his parents' decision.
And again, so I'm just feeling my way with this because they weren't thoughts that I'd had before we sat. But the description in paragraph 42 is one that could be made about any young person who's taken from downtown London and moved to Ghana, cultural shock, unexpected, unprepared, balks at the power outages. It's not an indication that the judge has heard this young person. That's paragraph 2 of the first statement. I want to say right from the very beginning, I am really, really struggling in Ghana. I hate it here. There's no other way to describe this, but I feel like I'm living in hell. 42 doesn't
engage
with that, does it?
It does him a disservice in terms of the strength of his feelings, in terms of his individuality, but also it doesn't...
And that's what the case is about.
Indeed, and it doesn't acknowledge a fundamental fact, which S was very keen to convey in his evidence to the judge, and that is that he is a British boy, a London boy. He is the child of Ghanaian parents. He is a child who has a familiarity with Ghanaian culture and who has visited that country a number of times. But he is a British boy and he wants to live in London. And he has always lived in London. And the real difficulty with the paragraph 42 is, I used the word reductive earlier on, but it simply doesn't begin to grapple with the emotional harm that this child has suffered as a consequence of the decision. And if it was only about lights and access to the internet, then that may well be an appropriate conclusion for Mr. Justice Hayden to reach. But that simply doesn't at all engage with the position that the young person was in. And that, of course, is where we, if you like, begin and end in terms of the obligation to consult and the consequences of not doing so and the parameters of parental responsibility. Moving a child from one country to another is a very significant decision. And it may well be a decision, and we accept that it is a decision which is in the bounds of parental responsibility, but there is a welfare element to it. And my Lord has put it much more elegantly than I have, but that is the fundamental point which is at the heart of ground 1 and indeed ground 4.
Is this a convenient moment to ask about paragraph 34, which takes us back to the debate we were having earlier? Because the judge says there, I adjourned this case in November because there was no coherent plan to accommodate S's return. I considered it necessary, I emphasise the word necessary, for there to be a clear plan if I was going to be in a position fully to evaluate S's options. Now, you made the point earlier that as at the 18th of February, there was still no clear plan. There had been zero change in that regard, and hence the discussion about a Section 37 report, a second one, or other options. And one of the points that was put to you by my lords in the course of the discussion was no change today. And I'm still not clear what your response to that is. There's still no clear plan.
Well, there are. There is no clear plan, as in there is one proposal. There are a number of proposals that this young person considers are viable. And in my submission, they are potentially viable proposals for a court to consider. As I said, there are relatives out of London, a relative out of London, but there is also the proposal that the father himself made, which is that he would live separately with the young person. And then there is the proposal of foster care. Now, it's a separate ground, but there is a difficulty with the way that Mr. Justice Hayden deals with foster care, in that he accepts a submission from Miss Fuchs, and it's a well-founded submission that children in foster care do not fare terribly well. But it's a very global submission, and it is not one which is properly explored in this case. One has to consider that children who go into foster care go from a range of different destinations, as it were, and that impacts on the well-being of those children. But if one stands back at the beginning of these submissions to the court, I drew the court's attention to how unsettled this young person's life has been since this decision was made. This young person has had 3 different placements.
Yes, but I'm sorry to be constantly coming back to the same question, but I'm still puzzled by what your submission is. Because on the one hand, you point out very clearly that the judge has recognised the need for a clear plan. He's recognised in paragraph 38 that return prior to conclusion of a second reform would be premature. And I understand that you argue you can't make a welfare assessment without knowing what the options are. But what's the follow-through in terms of the legal error?
The legal error, I think, begins at an earlier stage, if I may. The way that the judge comes into the analysis is flawed, we would say, because he is supposed to, based on my Lord the President's decision in Regi and the decision of this court in BS, the court is supposed to consider all of the available options, look at their benefits and detriments, and the welfare benefits and detriments to the child of each of the options. If, on the other hand, a judge comes into that analysis in a linear way, then he is not weighing the options, the benefits and detriments, against each other.
I'm very sorry. I'm obviously being very dense here.
No, it's me. I'm sure it's not you.
I'm struggling because it seems to me the reality of what you're saying, maybe the reason why you're not saying is because you know it's not legally well founded. But it seems to me what you're saying is he was not in a position to evaluate options, because as he himself recognised, he didn't have the requisite information. Isn't that what you're saying?
I don't mean to frustrate the court, but I think I'm saying something slightly different. I think what we are saying to the court in relation to this ground is that the exercise, the analytical exercise in which he engaged is flawed. And it's flawed in a number of respects. It's flawed because the judge starts it from the point of view of looking at the reasons why the parents took the child to Ghana, their entitlement to reach the conclusion that they did as to the jeopardy to his welfare, and the judge's apparent acceptance of the evidence of the social worker and the judge's own view that that was a reasonable decision for the parents to take. And he then goes on to consider other options. That is,
Yeah.
in my submission,
But you
one
can't,
error.
if that's your case, you can't really, can you, argue that we should make an order that the child be returned, the young man be returned today? Because as my Lord's getting at, the options weren't sufficiently coate. I hope I don't put words in his mouth, but the options weren't sufficiently coate at the time before the judge for that to happen. And they're not now. Are they?
There are.
I mean, recognise you have your instructions. So
There are. I think there are two ways of looking at this. One way of looking at it is as it were, through an analytical. To look at the analytical approach taken by the judge, which is the point I made a moment ago, which is the linear analysis point. Does he go into his analysis from the point of view of accepting or assuming that the parents' decision to move this child to Ghana had to be weighed against other decisions? The second, and of course we were aware of this and sought to assist the court in relation to this at first instance. If the criticism of the options is we don't know enough about this option, or we don't think this option is going to work, or this option hasn't been properly explored, it's a difficulty in my submission to dismiss the option. And that is something that we say Mr. Justice Hayden does. It can't be right that a court simply reaches a conclusion that a child could not, for example, be placed in foster care because the outcomes for children in foster care are poor. It can't be right that the court is so reductive in its dismissal of the father's offer to move out of the family home and to live separately with this child. Now, a consequence of that, the judge says, is that would deprive the sisters of the company of the father. But look at what's happening on the other side of this. One has a young person deprived not just of the company of his sisters, but both of his parents, and living in another country. So that's the difficulty. I understand the point my Lord Justice Arnold is making to me, which is, if as I understand it, the issue is if there was an inchoate plan before Mr. Justice Hayden, then that is an evidential issue. It's not a legal issue. I think that's the point.
But it's also a case management question.
Yes, I understand.
Because one answer, which might have been available to the judge, was to adopt your suggestion of a second Section 37 report. And one of the questions is, well, why didn't he do that? And it's not clear to me from the judgment what the answer to that question is.
Well, I think listening to this discourse, there's two different perspectives, and that's why there's maybe a misunderstanding. The submissions you're making, Ms. Fottrell, are relatively high-level legal structural submissions about the way the judge approached matters, looking at parental responsibility first, and then moving on. We three are judges, and my lord's asking the judgy question, well, what was the judge going to do, and how was he to do it on that day if, in fact, the evidence didn't give him properly fleshed out options? And so to reply to that, as you have, because you're in ground 1 and 4, where you have is understandable from that perspective, but that's really where we are at. And I think for my part, with your round 1, you're justified in saying that the judge didn't need to or shouldn't have audited the parent's exercise of parental responsibility and come to a view that it was within the generous ambit and that the state shouldn't interfere, because that wasn't what he was there for. Mm-hmm. He was there to do right by his ward and make a best interest decision. Equally, we can point to the parts of the judgment where the judge moves on after dealing with PR to actually do that job and look at the best interest decision. And structurally, that's what he does. And he says 3 or 4 times that's what he's doing, that he's made his own decision. It's not the social worker's decision. He's not gone with Miss Fuchs saying don't interfere with the parents if they got it basically right. Mm-hmm. He's got a response. So he's done that. The question is, did he do that exercise properly with the welfare balance? And we've teased out questions of that. Then, as my lord's point is, even if he'd done the well, and my lord says even if, but if the welfare balance was undertaken, how could the judge have made the order you wanted? Because there simply wasn't a plan A, let alone a plan B or plan C that he could press the button on and go forward with.
Well, I think it's probably important that I just revisit what S's position was before Mr. Justice Hayden. I recognise the deficits in the evidence, and I recognise the point that my lord is making. But may I just clarify? Before Mr. Justice Hayden, S's position was that he could return to the UK into any one of those 3 options. The situation with his father was something which emerged during the course of evidence, but it was something on which we took instructions. Yeah. And so, although those options needed fleshing out, and perhaps it wasn't a get on the plane tomorrow situation, those were options that were before the court. If the difficulty is that those were options which hadn't been properly analysed, that was also a point that we made before the court, and if it wasn't a Section 37, then it's my lord the President's point that there were other legal mechanisms that would have allowed the court to obtain that evidence. But on either view, whether it is these are options that are before the court that need to be fleshed out, or whether they need to be analysed or further assessed, it isn't an appropriate response for the court to say these options as they currently present themselves before me are not good options. And that is the criticism that we are making.
It's the premature.
And perhaps it hasn't been terribly clearly set out by me today, but we accept that the court needed assistance in relation to options. That is why we suggested the Section 37. But if a more appropriate route was simply to hit the pause button so that the options that the court wished to have further information on were properly explored. The frustration and the challenge for S was that although I accept that counsel and those representing the child had the obligation to present these options, because nothing had been done by the local authority in terms of any assessments of those options, and the parents had reached a very clear view. And we understand why that is the case, but it meant that S was pushing matters forward and not in a position perhaps to assist the court as much as he would have wished to do. But it can't be an answer to that to
well,
say.
there we are.
Can I take you back to ground one and
Yes,
ground
please.
4? Because I think I now understand how you're putting it. You're saying that, yes, he did refer at various points to the best interest welfare analysis. But when he did so, he was at all points viewing it through the prism of the parents' exercise of their responsibility.
Yes.
And you might say, I think, that that's illustrated by how he dealt with the issue of the harm that the young man is suffering and has suffered as a result of going to Ghana, being sent to Ghana.
Yes.
He talks a lot in the judgment, rightly, about the concealment, the subterfuge, and the impact of, is it 33, the impact on the young man of that. But your point is he doesn't consider the current and ongoing emotional harm that his predicament in Ghana will cause.
Indeed. And the risk of
And
future.
if we look at paragraph 42, which is where one would expect to find that ultimate evaluation, he talks about cultural shock, which he was unprepared, etc. Then he looks at positive features for him in Ghana. But nowhere does he cite the current and ongoing emotional harm which his isolation from his family is causing him there.
Indeed.
And that's because, you say, he's looking at it, the issue, through the prism of the exercise of parental responsibility, which he comes back to at the end of the judgment.
Yes, precisely.
Okay.
And of course, my Lord the President's point about aspects of the welfare checklist may have assisted the judge to properly identify harm. If one looked at the age of this person, if one looked at the sex of this person, if one looked at their particular characteristics, the particular characteristics of this boy are absent that analysis.
Might it be said, I don't want to interrupt you too, might it be said that the further one gets away from the conventional factual matrix in children's cases, the more important it is not to lose sight of the welfare checklist, however familiar one is with it. I was advice to myself. I was advice to myself rather than anybody else.
Well, my Lord, the welfare checklist is there for a reason. It provides an evidential analytical framework. And of course, it's not a straight market for judges, but if one asks oneself the question in paragraph 42, what is it about this particular boy that means this is either going to be harmful to him in a way which is not tolerable, or it is something that he's going to be able to manage, then it lifts the bonnet on who this young person is.
So, now I've got an eye on the clock. So, for my part...
I don't intend to address you further on ground one. And ground four, I think
we've certainly got ground one, and we're assisted also by the interveners' submissions on those big structural points. But for my part, and I think the Lord Justice Baker in his way, and then the Lord in his way, we're more interested in how the judge evaluated the best interests and what on earth he was able to do at that hearing that enabled him to make a final order dismissing the application.
Yes. My Lord, I hadn't intended addressing you much further on ground one or ground four at all, right. Unless you wanted me to go further into this last question that you have posed.
No, I think if you've got that, we've got
I've covered
points
the
that
ground.
you've made.
May I also say, in relation to grounds 2 and 3, which deal with the obligation of the judge to take into account the views of the young person, the wishes and feelings of the young person. We've covered this in some detail in our skeleton, and I only wanted to make a few very brief points really in response to points that are made by others. Our global submission, of course, is that Gillick is fundamental to this decision as it is to any other decision, and the fact that it's accepted across the board that this young person was Gillick competent is a matter of some significance. It seems to be suggested by Ms. Fuchs, and she'll address it, I'm sure, herself, but it seems to be suggested by Ms. Fuchs and Ms. Baker that Gillick has limited application to a decision like this. And if that is the submission, in our respectful submission is that is wrong, Gillick has much wider application, of course, than medical decisions. It predates the Children Act, in 1986 decision, and it's very clear that Section 3 of the Children Act and the Welfare Checklist is informed by the principles set out in Gillick, and there is ample case law from this court and from courts at first instance about the importance of children's wishes and feelings being elicited, consulted, ascertained, and given due weight.
Well, can I ask you about this question? Because I noted that dispute in the skeletons and the written submissions from the interveners. And can I put my question in this way? What is the best authority from your perspective for showing that Gillick is not limited to medical questions?
It is the decision of Mr. Justice, Lord Justice Mumby, in the case of Re X.
S. X?
Forgive me, X. If we just go to the authorities bundle, I think we excerpt this in our skeleton. Which is, I think, it's not in the authorities bundle, but I think it is referred to by my Lord the President in the E case.
E minor blood.
Indeed, and we refer
Tab
to
7.
it. Indeed, and we refer to it in our skeleton. So perhaps if I first of all look at our skeleton.
What are we looking for a reference for?
Just give me one moment if you
Yes,
don't mind.
okay,
I'm
sorry.
just coming out of the judgment. If we look first of all at page 28 of the core bundle, and that is our skeleton argument, and we excerpt there the relevant passage from my Lord's judgment in the Re E case. And of course, in the Re case, my Lord referred to the...
Well, can I help you? I think the page that you were intending to refer to in the authorities bundle is page 262, which is my Lord the President's judgment in Re E,
Yes.
quoting a passage from Re X. Is that what you wanted?
It is, thank you. And also, just for the court's reference, we excerpt some of this in our skeleton argument at page 28, paragraphs 32 onwards. So I hope...
Sorry, the question I want to come back to is what's the strongest authority for the proposition that Gillick competence is not limited, or the effect of Gillick competence is not limited to medical decisions? And your answer is Re X, but Re X was a case about a medical decision. It was blood transfusion for sickle cell syndrome treatment.
Well, my Lord, the decision or the observations of Lord Justice Mumby in that case, in my submission, go beyond the parameters of medical decisions. And
Is Mabon anyhow?
Mabon and Mabon.
Mabon, is that what it's called? Well, we haven't got that in there.
well, there's a... Mabon and Mabon is an authority for the use...
But it wasn't a medical case.
No,
No,
it was a
children-
private law case.
Two of the children were can't be Gillick competent.
Indeed. It's a private law case about representation of children relying on Article 12 of the UNCRC
Yeah.
and Lord Justice Thorpe's.
So it's not directly Gillick competent. Certainly, my approach to it's one of these questions that ask family lawyers, as my Lord rightly does. I've always taken it as read that Gillick competence is a competence that someone has for a range of decisions, not confined to medical matters, but whether over the luncheon adjournment further research can be done. And if I'm wrong in that, I'm quite happy to be told.
Well, my Lord, perhaps we can deal with it over the lunch in adjournment and come back on that point. But there, we excerpt a number of authorities, and I accept my Lord's point that they're primarily related to medical decisions. There is the A and B decision of Mrs. Justice Leven. There is my Lord's decision in Re E. There is the President's decision in Re X. But
most of the decisions of that sort of nature, where there's a binary choice to be made, are in the medical
yes.
sphere.
Well, there are also, my Lord, decisions in the medical sphere very often put a parent in opposition to a child, or a child's autonomy, or the child seeking to make an independent
If we can't answer my Lord's question directly now, you will do that after lunch.
So I didn't intend, I had started by saying I didn't intend to address the court at length about the issue of the views of the young person about the autonomy of the young person and the requirement that as part of a welfare best interests analysis, the court has to properly engage with that. We make a number of criticisms in our skeleton argument of the way in which Mr. Justice Hayden engaged with that, but I don't intend to amplify those orally unless you wish me to.
Can I just go back to Gillick competence? The proposition I'd like to put to you is this, that Gillick competence is in fact confined to medical treatment, and that the proper approach in other areas is to apply the statutory principle, that you take into account a child's wishes and feelings having regard to their age and level of understanding. That's the alternative proposition that Gillick competence arose in the pre-Children Act context of a very particular example of medical treatment. It's been extended to apply beyond strictly contraception to all areas of medical treatment, but that in decisions generally about children, it's the statutory principle in section 1, subsection 2A of the 3A, 1.3A of the Children Act, and 1.4A in the other act, the 2002 Act. Do you want to come back to that after reflection?
My Lord, I think I would want to come back to the court on that, because the decision in Gillick, in my submission, goes further than simply medical treatment, and it's the expansion of it by Lord Donaldson in the REW case as to the impact of it, and then the...
Well, shall we not take time now if you're going to come back?
Let's pause.
Let's do it.
I didn't intend going much further in terms of submissions, and I'm happy perhaps I can answer that in response to anything that is said by Miss Spooks, if she wants to make good that submission, and then perhaps I can respond. I have my eye on the clock, and I see the court has its eye on the clock. In relation to grounds 5 and 6, I don't intend to amplify those beyond what's in our document.
No. Anything else? No, thank you. Anything else? No.
I'm going to just check. There may be one or two.
No,
It may be a matter to come back and to assist the court to give me on, but one of the, just to respond to one procedural issue which arose, which was how was the case put by the young person in the court below. In a skeleton argument which was lodged with the court at the March hearing, there was, as it were, side-by-side analysis of all of the options. That is not a document which is before the court, but it is a document that we can make available to the court. So when my Lord asked the question, what were the options that the judge was considering, how was the judge to consider those options, what would the practical
Sounds
consequences
like it would be useful for us to see that.
Yes.
Yeah.
There's nothing further from me unless you
No,
want
well,
to
that's
address anything.
very helpful and very grateful to all who've contributed to the preparation of your side of the case.
Thank you.
Yes, Miss Fuchs.
My Lords, thank you. May I also start with a short factual update? S continues to reside with the same family members in Ghana with whom he has been since October.
Yes.
He is indeed now attending a local day school, which he started in March. The reports to the parents are that he appears settled and is making good progress there. Daily contact takes place between S and his father, either by telephone or video or message, and promisingly and significantly, contact between S and his mother has now resumed. that is a very welcome development from everyone's perspective.
Yes.
And what about his siblings?
I understand that contact between the siblings continues as
In the
it
usual
has done.
young person's way.
Yes. Miss Fottrell described S as a litigant who doesn't particularly want to be here. And I think that that is a fair description as well of these parents who, as my lords will be aware, found themselves in a wholly invidious position in March when they made the decision which they made. And I will come back to the factual matrix that Mr. Justice Hayden had before him when he made the decision which he did in February. We are dealing, of course, with a teenager. He is a young teenager. He was 13 at the point that he went to Ghana. His application was brought, importantly, within wardship, and he was entitled to make that application as of right under the rules. There was no leave requirement. And, of course, the wardship itself is both a protective and a guardianship jurisdiction, and engaged with his welfare interests. If the application had been made under the Children Act, he would have required leave. And that is one of the areas where Parliament has made clear that the court needs to look at a child's sufficient understanding in order to make the proposed application. And that's under Section 10, subsection 8 of the Children Act. May I just look a little at the decision itself and the context in which it was made? Because it was made at the conclusion of a 3-day final hearing. The court had written evidence from both parents and from S himself. The court heard oral evidence from the father, both in November and in February, and also from the allocated social worker in November. Case management of the proceedings had included directions for disclosure not only from S's school but from the local authority case records, because they had been involved with the family. And, of course, significantly, the preparation of a Section 37 report. So there was, we say, a wealth of information before the court when Mr. Justice Hayden came to make his decision, which was in no way a summary process. Importantly, I say, are the positions that were taken by the parties at the conclusion of the hearing on the 18th of February. S's position at that hearing was that the court should order his immediate return to this jurisdiction. That he should be placed in foster care by way of an interim care order made ancillary to a Section 37 direction. Parents opposed the application for return on the basis that they said that the best place for him was to remain in Ghana. And the local authority, which was present throughout all 3 days of the final hearing.
In what form? Represented or social worker?
So in the 2 days in November, the social worker and team manager were present, unrepresented. On the 3rd day in February, their solicitor was also present.
What was their position?
Their position was that they stood by the recommendations in the Section 37 report. And they reconfirmed to the court that, in their view, the grounds for making an interim care order were not met. So at the point that the court determined...
Judge didn't decide that, did he? He didn't make a finding as to whether the grounds for making an interim care order were or were not made out.
No.
Because it wouldn't have gone because on his welfare analysis, S wasn't coming back.
Yes.
But in terms of looking at the options, he didn't follow that particular line down to a conclusion as to whether it was an option, an ICO or not.
He made, I will say, a best interest decision about where the best placement was.
Yes, but he did.
for
But
S
I'm
in the
not
circumstances.
being clear. If the grounds for making an interim care order could not be made out, then it was not an option.
No, indeed.
And he didn't come to that crisp decision one way or the other.
He didn't make a finding as to whether interim threshold would have been crossed or not. Yes. That, of course, is separate from if it were crossed, what the right interim placement would be.
Wondering in what context he would have made that.
No, only if he'd been looking at all the options.
Well, and also, given that the local authority weren't proposing, given the outcome of their Section 37 investigation, the question of interim care threshold didn't arise.
Yes.
Yes, no, you wouldn't want what jurisdiction. Yeah. Anyway, there we are.
Yes. And importantly, I say, although it is now suggested that the court lacked important information to undertake the welfare analysis, in fact, S's position was that the court could and should decide the main welfare issue, which was whether he should remain in Ghana or return to this jurisdiction, because it was his case that the court could and should direct his return.
Well, undoubtedly that was S's primary case, but one sees from paragraph 36 of the judgment that there was an alternative case put forward by Ms. Bottrell at the hearing, which was that there should be an adjournment for a second Section 37.
That was put forward. That option was put forward during the hearing itself. I don't believe that it was flagged within the revised skeleton argument for the hearing in February. The proceedings were adjourned for around 12 weeks, I believe. The proposals for family members came from S by way of a statement dated the 5th of February, and the matter was back in court on the 18th of February. At no point was there, as far as we are aware, any direct contact with the local authority inviting them to undertake any form of assessment. There was no direction sought from the court in November that they should do so.
It's one thing, and it's important and helpful to understand the position of the parties, but if your submission is going to be that in some way, because S and the team representing him didn't do what you've just described in terms of asking for further assessment and weren't putting forward any option other than immediate return, the court was prevented from making its own decision separate from the parties' positions, then, as you were shaking your head, I would encourage you to carry on shaking, because particularly these were wardship proceedings. The judge had a responsibility to do what was right, even though the young person, perhaps in a fairly immature way, was saying, I want it and I want it now, give me the return order.
My lord, I accept that entirely. Had the court taken the view that there was a lacuna in the evidence that needed to be filled in terms of family placement in this jurisdiction, then of course the court could have directed further information to be provided.
And where we've got the position, as Ms. Bottrell described, with S either not being in a position to or deciding not to, for example, contact the aunt, and the parents weren't putting in any evidence from the aunt, but the judge wants to know, or ought to want to know, what the aunt was going to offer, if anything, then the judge has a responsibility to get onto the front foot and make directions for the filing of evidence.
My lord, that's right, but of course he undertook a best interest analysis of the option that the parents were putting forward, which was remaining in Ghana, versus the options available to S on his return to this jurisdiction.
But did he? Because where does the judge conduct a best interest analysis with regard to the option of placement with the aunt?
Well, he doesn't specifically address that. There was no evidence before the court about the aunt. I accept that. But the court is looking at realistic options for the placement of this child.
Is it your submission the judge was entitled to dismiss out of hand the option of the aunt without even giving any reasons for that?
Well, I don't accept, my lord, that what he did in not giving consideration to it was to dismiss it out of hand. The evidence before the court was at most speculative, because what the court had before it, and this is in the first supplemental bundle,
So the first supplement came out. So what are we looking for?
it's page 197.
Thank you very much.
In the child's third
Third
statement.
statement. This is a statement dated the 5th of February.
Right.
So the evidence about the aunt in question is at paragraph 17 on page 197. That is it.
Sorry, which paragraph? Because there's two aunts discussed on that page.
It's the aunt in
17.
paragraph
17.
17.
17, thank you.
Haven't we got this statement in the main? What we had?
280 of the main
Yeah,
bundle.
so 280, yeah. No, it's different.
Sorry, 274, my mistake.
Yeah. Yeah.
So he says he's close to that aunt. He says he's been to her house before. He says he doesn't think changing school as he would have to do to live with her would be a big issue. So why is that not an option to be considered then?
Well, my lord, the position which S was taking was not, in fact, that he should be returned here and placed with her. The position was that he should be returned here and placed in foster care, and that further inquiry could be made of the aunt.
Well,
Once
I understand that. You've made that point very clearly, and I've got that on board. But what my Lord the President was putting to you was that even if the judge didn't think that that was correct, did the judge not retain a responsibility to kind of consider other options? And I thought you had accepted that, and your answer was that, as I thought, was that this was a speculative option. And what I was wondering was why you describe it as a speculative option in circumstances where the evidence you're pointing us to seems to be putting it forward as a realistic option. Now, whether it's in truth realistic, I don't know, but that seems to me the gravamen of that paragraph, isn't it?
Well, the court, of course, had to grapple at that point with the fact that these proceedings had been ongoing for a while. There had been a 3-month delay in the final hearing. This is information coming from S. There had been no approach to the aunt in question. And I can say that certainly my clients would say it's not a realistic option. And ultimately what Mr. Justice Hayden considered was the harm which S would suffer in this jurisdiction was greater than the harm which he would suffer if he were to remain.
You say that that sentence at the end of paragraph 42 encapsulates all options, do you, for return here? When he says, I consider S is at real risk of suffering great harm in returning to the UK, that's on the basis of all options for realistic or feasible options for S's care here. That's all wrapped up in that sentence.
Well, my lords, yes, because...
Last sentence of, penultimate sentence of 42 in the judgment.
Yes.
Even though he hasn't mentioned the aunt.
Well, he considers he has made findings about the harm which S exposed himself to within the United Kingdom.
Yeah.
He considers that were he in foster care, there would be a risk of absconding and returning to the area of focus. He has no information about whether or not this aunt is even willing to put herself forward as an option. And we know that within the family court proceedings that we are looking at realistic options for the care of this young man.
Could I at this point ask you the question I put to Ms. Foster earlier on, which is, if this appeal is dismissed, what happens then? Question one, where will he be habitually resident? So which country's courts will have jurisdiction to deal with him? And who has responsibility for him if he remains in Ghana?
Well, the parents continue to exercise their parental responsibility and they delegate to family members as necessary. Yeah. But there is close contact between certainly the father and S. Decisions made about school were made between them. There has been communication about future education come September. That was all evidence which Mr. Justice Hayden heard back in February about possible boarding school options for him there.
And what about habitual residence?
Habitual residence. May I take instructions? Because, of course, I recognise that the court may be concerned that on a factual basis that potentially S becomes habitually resident in Ghana. But it may be that my instructions are that the parents accept that he would remain habitually resident.
Was consideration given to the wardship continuing, not after, because obviously that would provide a vehicle for any future further decisions down the line, even if the judgment is upheld?
There was no active consideration on the 18th of February about that as an option, I don't think. I don't recall.
Thank you.
Right.
Certainly it was the parents' position that the wardship should come to an end and that was the order that the court made ultimately after its decision.
Yeah. Well, we've reached a pause. Are there short submissions you'd want to make before the luncheon adjournment, or would you prefer to come back and start afresh.
May I come back?
Yes.
And I can deal with that.
Yes, and I think that we'd be particularly keen to hear your submissions on really two points. One is the any more submissions on this point about options and whether it was premature for the judge to close down the wardship and for the court to walk away at the stage that he did. And secondly, the bigger question of in conducting the best interests evaluation that he undertook, whether that was a proper, sufficiently full evaluation, or whether it was, as my Lord characterised Miss Fottrell's submissions, one that was flawed because it was conducted through the lens of his conclusion about the reasonableness of the parent's exercise of parental responsibility. So I think that's where the case is
Yes.
now, and we'd welcome your submissions, particularly on those points.
Thank you, my lord.
Good. We'll come back at 2 o'clock.
All right.